Okay. So good evening, everyone. I am Peter Gosselin, and I'm the vice chair of ANC 34G, and I'll be chairing the meeting, at least for the time being, until our chair, Lisa Gore, arrives. Tonight's meeting is a special meeting, a virtual-only special meeting, essentially devoted to the issue of the district's proposed rezoning of the Upper Connecticut Avenue commercial corridor. I believe that we're going to take up quickly an ancillary issue. This will be the second of 3 special meetings we will have had on this issue, in hopes that we can come to some agreement among ourselves on a resolution concerning the proposed rezoning in time to present it to the zoning commission at the hearing that they've set down for this issue on April 29th. Before we get started, I want to have the commissioners introduce themselves, and then I want to talk a little about the rules of the road for this meeting and all of our meetings, and then we need to take up the agenda. So, Commissioner Nash.
Good evening, everyone. I'm James Nash, Commissioner for Single Member District 03 in the southeast of our ANC boundary.
Bruce Sherman.
Good evening, everyone. Bruce Sherman. I represent District 02, which is on the east side of our ANC Commission area by Rock Creek Park, north of Military, south of Tennyson, and east of Utah.
And Commissioner Sherman. I'm Commissioner Zeldin, sorry.
We look alike.
Yeah. So Michael Zeldin, 3G04, which is Lafayette and the environs around it.
Okay, and I'm Peter Gosselin, and I represent District 6, which is largely the west side of Connecticut, almost back to Friendship Heights with a peninsula to the east. This is just this issue, and along with almost every issue this ANC takes up. Oh, let me just stop 1 minute. Commissioner Lynch is joining us, so once you're on, Peter, would you introduce yourself? Saw him coming in. Peter Lynch, are you on?
There he is.
Yeah, hi, right here.
Just introduce yourself.
Peter Lynch, Commissioner for ANC 34G05.
So I'm chairing, Peter, I'm chairing the meeting for the start until Lisa arrives. Just to remind people of the rules of the road. This issue, like essentially every other issue this commission seems to have taken up in the recent past, is one that's hotly debated in the community. We ask all attendees, except for the commissioners, to speak only when they're recognized and to mute themselves at all other times so we don't end up with a lot of background noise. We will play by the rules we've played by all along. That is that commissioners and residents will have 3 minutes to make their points, with, if necessary, a 2-minute follow-on. But basically, everybody who wants to speak gets to speak at least once before anybody gets a second bite of the apple. And I just ask that, if possible, try to keep your remarks to 2 minutes. I've asked Commissioner Nash to be our timekeeper. We have found that in the effort to take a lot of community input, our meetings end up going hours and hours and hours, and we're trying to do something about that, if only because we're running out of patience. The commissioners are running out of steam here, and so getting, as you see at the beginning of this meeting, getting a quorum is getting difficult. So I encourage you to keep your remarks to the 2 minutes. So I think that's it. So let's turn to the agenda. I think Commissioner Nash has an amendment he wants to make before we vote on it.
Yes. I would like to amend the agenda for a discussion and possible vote on testimony that I would like to deliver to the Committee on Transportation and the Environment at the budget hearings to occur later this month.
Okay, fine. That added to the agenda. With that added, can the commissioners accept the agenda as is? All in favor, please raise your hand. Am I seeing everybody? That's it all, yes? Okay. Good. So let me just set the stage for, well, I don't think we have anything on the consent agenda. Is that right, Bruce? Do we have anything that you need to get approved?
We were going to approve the March 27 minutes.
Did you get those done? That's not the meeting that we failed to tape, right?
No, they're done and they were sent around, days ago. Prior to the last meeting when the same topic came up. So if we go ahead and approve those, we can hold off until the next meeting.
Okay, why don't we take it up? I don't think there's anything else on the consent agenda. All in favor of approving the minutes for the March 27 special meeting, please raise your hand. Okay, that's out of the way. Let me briefly set up tonight's session and then introduce some of the people who will be speaking. As soon as Commissioner Ferguson comes on, I'm going to ask him to be a co-host so that I'm not scrolling through this list trying to find people. This is the second of 3 meetings about the district's proposed rezoning of Upper Connecticut Avenue into 2 zoning districts, one for all of the extent of the Upper Connecticut Avenue from Livingston to the Chevy Chase Circle, except the community center library, and a second district with higher height limits, maximum heights for the community center library site. I asked that at this meeting be attended by the office of ANC's 2 lawyers, their general counsel, Denise Wiktor, and Denise, correct me if I've got the pronunciation wrong, and Andrew Gerst, a newly added land use specialist. In addition, Commissioner Sherman asked that 2 lawyers from the Office of the Attorney General's Equitable Land Use section appear. And I believe one of them, Alexandra Cain, is here. I'm not sure I see Max Tondro, but I spoke with him this afternoon. I know him well from small area plan days, and I assume he'll be online. So
he did have a commitment starting at 7:45, so he might, if he does join, it'll be brief. Alex, maybe if he's going to join at all.
Excuse me. He is actually not going to be able to attend. His flight wound up leaving earlier than he expected it to, so
Okay.
he will not be here tonight.
Okay.
I hope you can speak, Alex. That's going to really mess things up.
I was about to say, we're here primarily to observe. I'm getting over a really nasty case of strep throat, as you can hear, so my speaking voice is not anything that anybody wants to hear, myself included. So.
All right. Well, my suggestion is that, let me just say that we asked these people to attend to help us advise us on technical and procedural matters. There seems to have been some confusion about what purpose they were supposed to serve. We have received emails and letters from various advocacy groups. I think one of the things each of these lawyers will want to do is simply specify what they see as their job here. And I'd ask the audience to respect the limits of what they can and cannot say. With that, if all of the 3 of you would raise your hands, I see Alex, I'm going to promote you to co-host so that you're stuck on the front of the Zoom session with us. And if you could come online by unmuting. And Andrew, let's see, is Denise there? Is Denise?
I'm here. I just can't figure out how to raise my hand.
It's all right. You're on. Okay, and so with that, let's start with the two lawyers who agreed originally to come. Just speak briefly about what you see as the kind of rules of the road for your participation in this meeting. Denise?
Well, I'm the one who roped Andrew into this. I had thought we were coming to observe and to answer questions as we could answer them. I suspect a lot of questions we would want to take back and research and get answers back to the commissioners. Primarily, I thought we were answering questions from the commissioners unless they adopt something from the audience. I don't particularly want to be caught in a back and forth of opposing views within the commission. We're looking mostly at procedures, process. Merits are only on the purview of the commission, not our office.
Okay. And I guess in this regard, you speak for Andrew and Kent Boese, who I have just promoted also, who is the director of the office. Let me just say again, these are the limits that these lawyers need to live within. The reason we're doing these meetings is, one, to solicit public opinion about this issue, but also to work ourselves towards finding out whether we can write a useful resolution about these proposals in time to influence the zoning commission. And we will devote most of the next special meeting, which is next Wednesday, a virtual only meeting starting at 7 o'clock, to the effort to cobble together a resolution. Let's see, Alex, do you want to briefly say what you see as the rules of the road for you?
Yeah, so sort of similarly to ANC, we're really here to observe. We've been keeping an eye on this case, but we have not settled on what our final position is going to be. So we're here tonight basically to hear from the community and from the ANC to get a better understanding of it. So in that vein, I'm not really able to speak as to what the position of OHE will be ultimately, or opine on, any ongoing litigation that may be connected with it. So again, primarily in an observatory.
Let me just ask, so I understand it. Your office, this office within the Attorney General's office, will take a position, is likely to take a position on the proposal at some point in the future.
We are looking at the case, but that's really the extent of what I can say right now. Again, no final decision is made at this point.
And Kent, did you want to say anything, or does this sort of capture what?
Well, I'm happy, presuming you can hear me, I'm happy to make a brief introduction. I know most of you know me. I've been in many of your meetings running the technology behind the screen. So this time I'm on the other side of the screen. But I think Denise is correct. But I do think it's helpful for some context that land use support is a newer feature from the OANC. It was something created by legislation, and it falls within our purview of providing technical assistance and procedural advice to commissioners. We don't weigh in on the merits of the case. We don't weigh in or we try very hard to be neutral and support the commission in its decision-making process and make sure that the community, or at least the commission in service to the community, knows the rules of the road better, understands how zoning cases work better. And that's essentially where our focus is to make sure that as questions comes up, for instance, if a commission says, we don't know how you do such and such within, what's the process? We dig into it and then we get back to the commission so that they can better do their jobs.
Can I suggest that since the commissioners are trying to head towards crafting a resolution, that we start with a one question round from each of the commissioners, and then go to residents. is that acceptable to commissioners?
Sure.
I would prefer to have a round of questions myself after I've listened more to what others have to say. So I will yield back my time if that's allowed.
If it's all right with the rest of you, let me just ask a question that is nominally off the topic of this particular proposal for the Upper Connecticut Avenue corridor, but goes to the issue of how much influence ANCs, this ANC or any ANC at this stage of the game, can have on the zoning process. And I guess I'd address this to Andrew Gerst, who wrote me earlier this afternoon to say that the zoning commission today approved in a 4-to-1 vote a procedural rules change that at least I think, and I think a number of commissions think, drastically reduces our ability to influence zoning cases. This is so-called zoning case number 22-25. It also, at least a previous writing, exempted let me just break in here, and Commissioner Ferguson just joined us. And Commissioner, could you introduce yourself? And then I want to make you co-host, so you're watching the audience. Are you online yet?
Yes, hi, thanks. Zach Ferguson for Single Member District 07. I'm the ANC treasurer. I'm running late for my kids' extracurricular, but glad to be here.
And I'm making you co-host, so if you can admit people and keep when there's noise. Okay, so the question, Andrew, if you're there, could you just tell us what 22-25 does to the ANC's role in zoning cases?
Sure. Thank you, Commissioner Gosselin. I'm happy to be here. As Director Boese and Denise said, within certain parameters, but my understanding of what zoning commission case number 22-25 would do, can you all hear me?
Yep.
So it would have it has a new proposed subsection which would exempt rulemaking map amendments proposed by either the Office of Planning or an ANC from the requirement to provide notice of the public hearing to all property owners within 200 feet of the property. That is the subject of the map amendment. It also has a new proposed subtitle which would exempt Office of Planning and Office of Zoning text amendments that include related map amendments from the referral requirements.
That's a referral to us. That's a referral to ANCs, is that right?
Yes. And then it also has few time period changes, changing the filing the ANC sit-down form by the affected ANC from no later than 30 days to no later than 40 days after the date the application is referred. It would provide that a public meeting to consider setting down a contested case other than a map amendment shall not occur less than 45 days after the application is referred to the affected ANC instead of 35 days. So I think I captured that correctly. Alexandra may know if I indeed captured that correctly, but that is my understanding of what the ZC 22-25 case would do in terms of affecting ANCs.
And let me just say, I raise this with commissioners because this is an issue that your predecessors took up. We wrote a letter to the zoning commission in September of 2022 saying we thought this was egregious cutting back of our role in the process. My understanding is the proposal, at least in 2022, and this is the one that bothers me the most, appears to limit who can participate in any reconsideration of zoning decisions to those who have party status, a narrow category under current rules. Again, it would limit, not expand, meaningful community engagement. Now, I stand to be corrected about that because this may have evolved since the September 22 letter, which I authored. So, Alex, did you have anything more to add on that?
Just a little bit. I think Andrew did a good job of sort of summarizing it. And you're correct, Peter, they are moving forward with limiting reconsideration just to parties in the underlying zoning case. In terms of impacts to the ANC, just to sort of get into a little bit of the details of what Andrew mentioned, just for clarification. So what the amendment is proposing to do is require that OP and OZ text amendments, so like the text amendment 2025, would not need to be referred to ANCs prior to set down. So this is basically a codification of OP's current practice, which is to drop a set down report 10 days before the public meeting at which it is set down. So they're now just sort of making this a formal thing in the regs that they don't have to send this out to the ANCs, but that's effectively already what's happening. So that's number one. In terms of the map amendment, and just bear with me, I'm trying to catch up on this. So for that, the main issue there is that the notice of a map amendment that is filed by either the Office of Planning or the ANC as a rulemaking would not need to be sent out. Notice of it would not need to be sent out to property owners within 200 feet. So that is a current requirement for the regs. Again, they're sort of clarifying it in 2025. You know, the position that OAG has taken on both of those, that we think that they're problematic because they are restricting notice. It is making it difficult for ANCs and the public to understand, but just to sort of put a little bit more nuance on those two issues. So if there are any other questions, happy to answer
Well, I
them.
understand that. How would, so OP proposes to rezone my block. Other than going every day and looking at ISIS or whatever the zoning commission online thing is, how do I find that out before there's a hearing? As a commissioner,
That's a good question. So if it's a contested case, map amendment, which can happen even if it is OP, then they would be required to send out that notice to 200 footers. It's only if it is a rulemaking case. So that's sort of, I guess, a theme throughout 22-25 is this issue with notice of rulemakings, whether they're text amendments or map amendments, and throughout the whole process. Like I said, they are codifying that there would not be a referral to the ANC prior to set down, and then they're also codifying that there would not be notice given to the 200 footers of the hearing.
Commissioner Sherman, you raised some questions with the lawyers, and they sort of dovetail with this issue. I think you wanna pick up on one of those.
Well, let me start with the first one, which Andrew has already answered, but the public hasn't heard the answer, so let's put it out there, which is that the ANC was not properly noticed for the set-down hearing on November 9th. And when the set-down hearing occurred, Commissioner Hood decided that, and the zoning commission agreed, that they could waive the requirement to provide notice. In other words, in my paraphrasing of that action, they exonerated their own negligence. And I understand, Andrew, from what you've told me, we have no appeal to that. It's history now. It's a done deal. And going back and revisiting that is not going to pay any dividends. Is that correct? You're muted, I think, Andrew.
I know. I don't know what your appeal rights are regarding that. Denise or Alex may know better than I. But I did cite to you the regulation and the zoning regulations that appears to provide that the commission can waive any provision in the zoning regulations if they feel that a party was not prejudiced by it. I watched the November 9th hearing that you sent a link to, Commissioner Sherman, from last year, and there was discussion among Chairman Hood and Commissioner Miller and the other commissioners whereby Commissioner Hood did acknowledge that proper notice was not given to the ANC. However, he and the other members of the commission went on to say that they did not think the ANC was prejudiced by that because you had plenty of other types of notice, you were involved in other ways, and that if it was a survey that you wanted to provide as part of the record, Chairman Hood was going to give you as much time as you needed to submit that, and that they would consider it as part of the record. So that was my understanding of the discussion at the meeting on November 9th regarding this particular issue.
So let me add a wrinkle to that, which is I received a PowerPoint presentation, which I shared with the rest of the commissioners, which was prepared by the Office of Zoning for ANC's guidance to ANC involvement in zoning matters. And in that slide deck, that presentation, with respect to weighing in at a set-down hearing, the November 9th hearing in this case, the slide 15 reads, and in the case of a map amendment, the ANC could also weigh in on whether it should be a rulemaking or contested case. So by not having an opportunity to participate in that set-down hearing, we had no opportunity to weigh in if we had chosen to do so as to whether it should be a rulemaking or contested case. So it seems to me that it's not just a matter of whether our survey was pending and then we had plenty of time after that and everyone had plenty of time to look at the survey and understand the results of it. There was a procedural equity issue here at play that I'd like to ask you, Andrew, to opine on, and Alex, you as well, in terms of what we were denied in terms of process.
I think Alex and Denise could probably opine on it better than I, so I will defer to them on this particular question, if that's okay.
Sure.
Thank you.
Honestly, I would have to research, maybe Alex knows better because this is something I'm only tangentially involved in, but you know, in terms of the procedural due process issues. But I'm happy to research it and get back to you.
Unfortunately, I don't know how much of an answer I'm going to be able to give. I believe that these issues have been raised to the Office of Open Government and are the subject of an ongoing investigation. So because of that, I don't think I can really opine on it myself at this time.
So just to be clear, I'm not asking this on behalf of any litigant or anyone else. I'm asking on behalf of the commission, because we have, or do we have, even at this point, an ability to ask whether or not the hearing should be a rulemaking case or a contested case, separate and apart from whatever any of our constituents might be doing. I'm speaking strictly about what the ANC's rights and abilities are.
Sure, I will say I did pose a question to a contact person that I do have at the at DCAS regarding whether whether a party has the ability to contest, no pun intended, to contest the determination that a matter is a rulemaking matter or a contested case. I have not heard back from that particular person yet. So if and when I do hear back affirmatively one way or the other, I will certainly let you know, but I did pose that question.
So we keep this moving. Zach, do you have any one question for any of these people about the zoning proposal?
You're muted, Zach.
Are you talking about the Upper Connecticut Avenue or the issue ruled on earlier today?
Either one. I actually think they're related, given that I'm concerned that the procedural decision that the zoning commission has now made.
I was working all day, not checking my ANC email much, and got back from my kids' thing. And I looked at the old agenda, only had Upper Connecticut Avenue. So I was not getting ready to talk about the issue at hearing earlier today. So I'm more focused on Upper Connecticut Avenue.
Do you have any questions for these people on that? I'm just trying to get a first round of commissioner questions.
I actually do have a question now, Peter.
All right.
Is the zoning commission required to give great weight to any resolution we might pass?
The ONC lawyers who must know great weight better than.
This is Denise. Yeah, the zoning commission is required to give great weight, but great weight merely means that they considered your position and they have to give, the Court of Appeals has ruled, well, let me back up. They only have to give you great weight on things which you were legally required to get notice of. And once you get notice and weigh in on it, the Court of Appeals has further ruled that all they have to do is explain that they took give a written explanation as to that they took your comments into consideration and how they either chose to regard or disregard them. The very few Court of Appeals cases on great weight deal with the commissions that felt they weren't giving great weight, or it's not the commissions, but where commissions weren't felt to be giving great weight. And so honestly, it's better articulated positions, they would have to better articulate why they're disregarding them. But that's all they have to do.
Just so I understand, Denise, is there a reason, given the issues that Bruce raised about are we party to this automatically, so that not to the procedural issue, to the substantive zoning proposal for Upper Connecticut Avenue, as the ANC in the relevant area, are we automatically party to this? So they have to respond, at least respond to us and give us reasons why they're not paying attention to us.
They're required by law to respond to any any resolutions and positions you take and give them great weight.
Zach,
Just if I can jump in for a minute, Denise is correct. They have to give you great weight regardless. In a rulemaking case like this, the ANC is not considered a party the way that you are in a contested case, but they still have to give you great weight.
Can I follow up on that, Peter? Then this gets to the heart of my question and to the role that we can play, that we would like to play, given that it is a rulemaking case now. And if it were a contested case, that would give us greater opportunity to play a role if we so chose to play that role. As it is now, Alex, is it correct that we as an ANC would have the same 3 minutes as anybody else would have?
I believe as an organization, you get 5, and the commission, I think, has the ability to be flexible with that. And I think in practice, they do tend to be more flexible with ANCs and allowing more time as needed. But you would certainly have more than 3 minutes.
But essentially, just so I understand further, it is a presentation, not the ability to ask questions or to request additional information from another presenter or anything of that sort. We're given an amount of time, we make our presentation, we sit down and it's done. Is that essentially right?
That's correct for the hearing. Idea being that you have a more limited comment period there, but then you also have public notice and comment period that happens after the NOPR comes out, with the notice of proposed rulemaking, that you would then also be able to submit comments on. Excuse me.
Right. So I just want the commissioners, Peter, to understand what's going to happen and how circumscribed our participation is going to be, as well as the rest of the public's.
well, let me say, we can have a further and really deep conversation about how we play this out, but I would argue that we might be as effective in going after the procedural rules that just got made against us and winning back some of the abilities that we had prior to that rule being passed today, particularly on reconsideration. And piggybacking on, if in fact it's made a contested case by advocacy, the local advocacy, Chevy Chase boys, being sure we take full use of that status. Zach, did you want to say anything, or should we go to questions from the residents?
Happy to go to questions from residents.
So again, I want to emphasize, and I think the three lawyers have demonstrated vividly that they're going to be very circumspect in what they say. But I'm happy to, the people who are going to make the next decision about this substantive zoning proposal for our community core are the commissioners who are here. So if you want to speak, would you raise your hand and wait to be recognized? And Jim, will you do the honors of time? Okay.
Yeah, Peter, is the limit 2 minutes?
So, I mean, I think that, the published thing says 3 minutes. I think you ought to just let people know at 2 that there are
All right.
folks who want to make comments. It would be a rare meeting. Nobody raised their hand. Conn.
Yeah, hi. Thank you very much. I want to ask a question, given that we have zoning, well, we have representatives from the AG office that I didn't realize was on here, so I changed my question. So here's my question. Is there a defined criteria for rulemaking decisions by the zoning commission when are there guidelines related to such a critical binary decision that should require a very high bar versus contested? Do you know what the criteria is? Is it clear?
Are you talking about the criteria for what constitutes a contested case versus a rulemaking?
Yes.
So those standards are in the zoning regulations. I can pull them up. So the criteria for contested cases and rulemakings are found in subtitle Z 201.2 and 201.5. And those go through that. We'll note that in Z 201.9, it does give the commission flexibility to make a determination as to what type of case it should be. But those are where the standards are in the regulations.
Alex, just because it's confusing, we have 2 commissions here. You're saying it gives
The zoning commission, I'm sorry, Peter.
Okay.
Is it clearly defined in terms of that support of that decision that they made, for example, for 23, 25?
I mean, I want to be clear, I've not watched the video of that hearing. I can't opine on what the commission did there. So really what I can point you to is the language in the regulations is currently written.
Okay.
Go to Cheryl. Cheryl Barnes.
Hi, can you hear me?
Yep.
Great. Good evening. I am two things. I think that everyone in the community, including the speakers here, would benefit by seeing that video of the set down hearing on November 9th. It's really instructive. The rules were waived without authority. And just to go back to the Office of Open Government complaints, actually, there is a major issue with waiving the notification like that and just waiving those rules. That I don't know if anybody here has read the findings or I should say the response that zoning made to the Office of Open Government yet. It is posted on the Zoning Commission website. So that's something that everyone should take a look at as well, so that you can familiarize yourself with the response to the complaints that CCV filed with the Office of Open Government. And just a word on that, it does state, even though Office of Open Government doesn't really have any purview in the matter, the Zoning Commission did state that they can set this down as either a rulemaking or a contested hearing as they see fit. And also for the record, Chevy Chase voice adamantly disagrees with that statement on their part. That's it. That's all I wanted to mention. Those 2 things, that read the Office of Open Government responses from Zoning Commission, and also review that set down video. Thank you.
So, Jeff Norman.
Yes, is this time to discuss the substance
Yeah.
of just questions right now?
No, you're welcome. I mean, actually, I was about to say, we've just spent a half an hour, 45 minutes almost talking about process and moving the discussion to the substance. Ultimately, this commission has to take a view of the substance of these proposals, of the proposals for these two zones. So have at it. Talk about substance.
Okay, my position is that I support these zoning proposals. I think they're good for our neighborhood. They're good for our city. I look at Connecticut Avenue as a major street in a major city, and it should be treated like major streets in big cities in the developed world, the US and other countries. I note that the first development that I was able to find and was in the area north of DuPont Circle in the 1890s. We have a 7-story building, the Dresden, that was built in 1909. That's 115 years ago. And as the city has expanded, Connecticut Avenue has allowed taller buildings to be built, although not that tall compared to many other cities, but taller buildings all through the past century or more. And in the area north of Military Road, Upper Connecticut Avenue, there are already 3 90-foot buildings. My building, the Kenmore, and the Livingston. And I think that allowing that in the zoning, and the zoning doesn't even go that far, but allowing that would be entirely proper, entirely reasonable.
2
So
minutes.
that's my position.
Andrea Rosen.
At this hearing on April 29th, for an individual who shows up to testify, are we expected to be talking about, I mean, are we supposed to talk about how we think it should be, whether we agree or disagree with the zone type, or in other words, the substance, or is it a place to talk about the process, to argue about contested versus rulemaking?
I don't have an answer for that. I assume it could be either one. If you think you can get closer to where you want to get via process arguments, argue process. And if you think that the substance issue is what you argue that. I mean, any of the lawyers have a view on it? Not a peep. I don't know. I don't know. We're as new to this process as you are. So we're actually probably newer to the process than you are.
I was thinking that one of the lawyers, especially from the land use section of the OAG, might say something.
I actually think, Peter, you summarized it pretty nicely. It's really your 3 minutes to argue or present whatever you to the commission, whether that's more on the substance or more on the process. Ultimately up to you. So yeah, I think the way that Peter framed it is actually pretty thorough.
Boy, it's painful to listen to you talk, Alex. I'm just out of curiosity, Andrea, I see that Ed Hanlon's on the line. Ed is the lawyer for Chevy Chase boys and has crafted a lot of the arguments that Chevy Chase boys has made that this is and should be a contested case. Do you want to say anything, Ed?
Thank you, Peter. Very briefly, and I'll be happy to answer any questions. It should be clear from the discussion, there's a fundamental difference between rulemaking and contested hearing, and which it is makes a big difference to everyone's rights. And Ms. Cain is basically correct that in rulemaking, everyone gets 3 minutes. Organizations get 5. And so you can line up, you can say your 3 minutes, and they go to the next person. In contested, as Mr. Sherman is pointing out, you can call witnesses. You can cross-examine witnesses. You can put on rebuttal evidence. You can introduce exhibits. And fundamentally, in my opinion, the most important thing about a contested hearing is you have the right to appeal the decision to the Court of Appeals. And you don't have that in rulemaking. Rulemaking is legislative. There is no appeal. And they don't even have to make findings of fact and conclusions of law. You can sit there all night for 3 minutes and testify. At the end of that, at midnight, they can make a decision. They don't have to analyze the whole record. They don't have to tell you in writing why they're doing it. And so there's big, big differences. Now, one important thing about the Office of Government Complaint, Office of Open Government Complaint, is when the Office of Zoning came in and replied, they said, this Chevy Chase case fits the criteria for a contested hearing and also fits the criteria for rulemaking. They concede that this case fits the criteria for a contested case. And then they came in and said, well, the zoning commission has the discretion or the sole discretion to decide which of the two it is.
2 minutes are up.
And of course, as any good lawyer knows, they don't have unlimited discretion. And I would argue that the balance of equities is whenever confronted with such a situation, you go with the type of format and procedure which affords ordinary people the most rights. When you have two choices of a procedure, you give the one to the people who have the most rights, and that is a contested hearing. Having admitted that a contested hearing is an appropriate procedure, that is the one that you should also choose. I'll be happy to answer any questions.
Let me just say oh, I'm sorry, Denise.
No, I was just having a thought, that's all.
All right. Let me just say this is just one commissioner speaking. In general, I had concerns about Chevy Chase Voice's argument, and I will about this needing to be contested. And I will go back, but I will go back and look based on what Commissioner Sherman said about exactly. I remember that we did not get clear notice, and it was a surprise given that we'd been talking to OP, and then suddenly the thing was into the zoning commission and we hadn't been told. I must say that I have more sympathy for the argument now that they passed this procedural change, which I think seriously undercuts ANC's role in this process. And it's really hard to think of a subject that is more central to ANC's portfolio than zoning changes in their own neighborhoods. So again, to Bruce, I'd say that I wonder whether a more fruitful route would be joining with other agencies and trying to get back the procedural rights we had before. But I will go back and look at the timing about when we finally really did know as a commission about the set down. Other residents with questions or comments about the proposal. If need be, I can review the bare bones of it, but that's always a dangerous proposition because in this issue, as it is in so many, the details are contested. Wow, we're going to be out of here by 8 at this rate. Brian. Cheryl, I'm waiting. I'm trying to live by the rule. Everybody gets one round before we go to you again. So Brian, comment?
Chairman Gosselin, members of the ANC and attorneys on the line. I just want to point out that the April 29th hearing is really only about the two parcels that are on which the library and the Civic Core and the playground managed by DPR sits. And Brian,
can I just correct you there?
Yeah.
They're about that parcel, but they're also about the rest of Upper Connecticut Avenue from Livingston to the Circle. They're proposing two different zoning districts. One for all of Upper Connecticut Avenue, except for the community center library site, and one and a more expansive one, a somewhat more expansive one for the community center library site.
And, you know, from my perspective, I saw Joel Lawson is on the call as well, and I appreciated his comments. But Joel, in his presentation about OP's planned presentation to zoning, pointed out that in the map, the future use of land map, there was both a coding for civic use and for housing on the in an element that was ultimately came out of the small area plan in a way that I think is presumptive and inconsistent with past use of the property. And I really think that from the zoning commission perspective, should be two separate hearings, one for the rest of Upper Connecticut and one for the Civic Core, which, you know, my own view is that giving away or privatizing any element of the Civic Core will forever impoverish future generations of users of that place, where our own kids use the library, community center. And there's no example of a Department of Parks and Recreation playground sharing the same physical space with housing. It's kind of it's a difficult thing to consider, but that is in fact what Gilles Stucker has said. This is the opportunity, is to co-locate two elements of our city functions, including DPR and other elements alongside privatized housing, which is something I certainly oppose. But I think they should be two separate zoning commission hearings. That's my comment.
As a procedural matter, to any of the lawyers, or as a procedural matter, is there a way to make that argument?
Thank you, Peter, and I'd be interested to hear what Ms. Cain has to say as well. But yeah, of course, you could make that argument. And of course, you could ask to split the hearing. And of course, you could ask, one of the problems, if you think about it, is if you're going to, the two hearings are very, very different in terms of properties and in terms of interest. So yeah, you could definitely ask to split it by motion. The problem, of course, is at the moment, no one is a party to the case, so no one has a right to file a motion. And that's one of the problems with rulemaking.
What I was trying to get at is, do we have any in here? I don't know. Any of the others, the three of you, want to comment on this? And after that, I'm just going to try to frame some substance questions.
But Peter, before you do that, can we just follow this through, because this is dangling. So so Brian makes an interesting point. If we wish to do this, since we're not party to the hearing, we don't have a right to do it. Although I go back to this matter of whether or not we can exercise. Do we have a right to exercise in the first place, Alex? And that would allow us to go to the zoning commission and appeal to be a party to the case? Or does it have to be already decided as a contested case for the ANC to be a party? Is there any other provision whereby we could become a party to the case?
I think other than need to double check it, but I believe an appealing, I apologize, I am really losing. Um, I think it would have to go back to an appeal or request for reconsideration of the contested case versus rulemaking. I would need to double check in the regs.
Peter, may I just follow up briefly, Mr. Sherman's question? We had the same problem, Mr. Sherman, at 1617 U Street project, in which it was set down as a rulemaking hearing in February of last year. And there are no parties, so there are no motions. Nevertheless, I filed a letter in the case, on the case docket, and I hate to say, indicating we may sue them, but that's what I did. And and through that letter, even though it wasn't a motion, the commission changed its position and reset the case as a contested matter.
Just
So,
to be clear, Ed, you filed such a letter in this case too, right?
in this case, I filed such a letter as well. Yes, and that particular letter, well, we still have the investigation with OOG, and we'll find out how this case may be reset. It almost certainly, the set down hearing almost certainly has to be held again, because the set down here is not published in the DC Register, and I don't know of any way to get around that. And maybe if they have to revisit, they'll revisit and do it as a contested matter. That would be I hope.
So, Ron Eichner?
Thanks, Peter. I just wanted to clarify one thing Brian said. The institutional and residential uses were not added in the small area plan, and I think significantly they were added in the amendments to the comp plan. So the comp plan now has a certain designation for the Civic Core site, which is, I believe, moderate density residential and low density commercial. So any zoning change, if people who are opposed to housing on this site, if they were to look to change the zoning to not allow housing on the site, then the zoning would no longer be consistent with the comp plan. So I think that would be an issue. But I am the furthest thing from a lawyer, so the lawyers can opine on that.
Okay, Cheryl? Cheryl Barnes?
Thank you. I'm here. Just on that last point, I think the no apartment covenants really inhibit the building of housing on the site, but that's my opinion. A couple of things. In the upper Connecticut Avenue, and actually all the way down Connecticut Avenue, and on Wisconsin Avenue, there are these big upzoning development plans. All up and down upper Connecticut Avenue and Wisconsin Avenue, we have rent stabilized buildings, thousands of units. In fact, Ward 3 has more rent stabilized units than any other ward in DC. And we have a lot of low to moderate income residents living in those units. Throughout DC, every time that neighborhoods and wards get upzoned, like these proposals are proposing, then displacement happens, gentrification happens, and all of those people get displaced. It's the way to increase the tax base throughout the city. I get that. But I just would like everybody to be aware that along with this upzoning and fancy new buildings also comes displacement and gentrification. And that's exactly the argument for doing this, is to build, affordable housing. It's not affordable housing. The new IZ units actually cost more than the rent stabilized units that are already in existence up and down Connecticut Avenue and Wisconsin Avenue. That, I think, is my answer to the Jeffrey Norman. I just felt like that needed to be answered, because this is not even part of the community discussion. We're not even talking about the displacement of people living in all of these rent stabilized units. It's happened in every single place that DC has been upzoned. That's my first point. I don't want to run out of time here.
2 minutes.
Go ahead.
Yep. The other thing that I wanted to say specifically regarding the upzoning and the OP set down is that from what I can see, it is a gross overreach of what the council approved with the Chevy Chase small area plan. A gross overreach. And that's all I have to say on that. That's it. Thank you.
Just a quick response to Cheryl. I just point out that the zoning proposals in this case focus on property that has no housing. Now, maybe you can make a case that there's some sort of spillover effect, but from Livingston to the Circle, I don't think there's any residential property on board. So let me, Bruce, if this is all, Robert.
Thank you, Peter. Something I'd like to have somebody clarify for me if they can is there on the Civic Core, there's, and this is my hobby horse, a no apartment covenant on the back 40% of the property. And that's in place now. There's, maybe somebody's contesting it. I know that Councilmember Frumin is contesting it, but right now it's in place. Suppose that remains, then what does the upzoning matter in that case? Maybe somebody can help answer that.
Any of the lawyers here?
Yeah, and also I believe the Office of Planning discussed this at the last meeting. If the covenant remains on the property, the covenant remains, and the zone, the upzoning it doesn't change that. But Councilmember Frumin, just as a point here, is not merely contesting the covenants. He's introduced legislation to erase the covenants. So that needs to be taken into consideration.
And I guess if I remember, I mean, we've been around and around and around this track in the last year on that covenant, but my memory is twofold. One is that the only parties who can go after it, other than the public entity, are parties to the agreement, and that is the city and Chevy Chase Land Company. And the other thing, as a practical policy matter, if it remains in place and remains in force, something as large as the maximum that the zoning commission changes the zoning to can be built there, just not housing. And on the other hand, housing can only be built on the remaining 60%, which would tend to drive how the height of buildings, subject that we spent a lot of time on, but I want to spend a little more on tonight. Drive the height of the building, the front 60% up. Elizabeth.
Yep, sorry, thank you. Just took me a second to unmute. For though, and nobody has mentioned this, but I'm sure that some people are aware that one of the partnership teams that's looking at the Chevy Chase Common site is comprised of developers plus a hotel chain, Rosewood. And I think it was you, Peter, who mentioned a while back that there was a possibility of a hotel. Before all this stuff kind of bubbled, to the surface. So while we're talking about creating affordable housing at the Chevy Chase Common site, I think it's worth pointing out that some people may not be focused on housing at all, affordable or not, and that we might find ourselves with a hotel on the property instead of any kind of housing, no less affordable housing.
Let me just be sure which Peter you're talking about.
I was actually talking about you, Peter. Gosselin.
I don't think I've ever suggested
I
that.
think you have mentioned hotels before in reference to this site, but I could be mistaken. We can go back.
I have mentioned hotels because it's in the RFP, and
Oh, sorry.
No, it's okay. And I asked that we remove it for just the reason that you're talking about, is that it opened up the possibility that hotels could be put at the site.
I think that's a real possibility. I don't think Rosewood is in it for fun. If they're interested in bidding on this project, they're interested in putting hotels on this project, I would presume. That's what they do. That's their business model. So thanks. I just wanted to point that out for the community because I do not want that to get lost in the discussion, that we're now no longer talking about affordable housing even. We're talking about hotels.
And to add to that, there's language in the RFP that suggests that retail could be expanded past what I think anybody conceived retail being at the site. So that's another one that I think is a surprising addition in the RFP.
So are there other questions? If not, I want to suggest a pivot to some substance. I think that there's an issue before this commission about, and before people thinking to testify at the zoning commission April 29th, whether you go the procedural challenge route or the substance route or both or neither. On substance, in years of hearing, in the community survey we did, we heard most vividly about two things that people think, as I see it, two things. One is maintaining the scale and texture of the core of our community. And that most importantly turned on height, and the other was green space. I'm curious, just I throw out this as a, if you think that whatever our views are, there's going to be some change on Connecticut Avenue in the future. What do people think of the idea of simply advocating for a single zone, the one that the lower of the two, the one that applies to the rest of Connecticut Avenue, and so that if I, roughly speaking, measuring height the way ordinary people do, right up to the top of a building, whatever the setbacks for penthouses are, it could be between 65 and 70 feet, depending on the high Z, rather than 80 feet. I'm interested in people's reaction. Andrea.
Well, this ANC passed a resolution that it gave to OP, I believe, or DEMPED, saying that 60 feet maximum. I don't think there's really much point in trying to negotiate because it doesn't really lead to, well, I've always been a believer that you should hold the line as opposed to sort of trying to negotiate, because these people don't negotiate. And I say that as a person who opposes residential use at the public site. But I'm just saying, I wouldn't start trying to, well, kind of compromise, even from where your standpoint was.
Others? Ron. Ron Eichner?
Okay, yeah, I'm sorry, I had trouble unmuting. Just super briefly, because it gets technical. The problem with setting a arbitrary height 60 feet because it's somehow a compromise between other higher and lower choices, is that building heights have to be set relative to the realities of building. And to make a long story short, if you set the height along the avenue at 60 feet, you do not, that does not allow additional density, which means that it does not allow increased opportunities for affordable housing. And the stated objective of the changes to the comp plan, of the small area plan, of the zoning, of every statement the mayor has ever made on this site, and every resolution the ANC has ever passed, is the purpose here is to increase opportunities for affordable housing. And unfortunately, 60 feet doesn't do it. There are probably other numbers, but it needs to be based on what's buildable.
Yeah, let me just say that besides whatever the imperatives of development are, there's also a political imperative that the community's got to go along with it, well, or go along with it to some extent, or there's going to be a long, likely legal fight. So trying, no compromise is a bad word, but trying to find some middle ground, not I think is a reasonable.
Well, a middle ground, I would define middle ground as to try and take everybody's concerns and goals for the site and synthesize it into something that works. It's not so much a compromise between positions, but something that achieves the goals as many as possible.
We're going deep into round two here. So Elizabeth. Elizabeth?
Sorry, it's always the unmuting part. I beg your pardon. It upsets me to hear anybody say that they're reluctant to take on this issue because it will create a political mess, for lack of a better word, or something that's politically unpleasant. This whole thing on Chevy Chase Commons and Upper Connecticut Avenue is politically unpleasant, and there are people in the community who want to fight it because we don't agree with the way this whole thing is being shoved down the throat of the community, and we would welcome a political fight about it. Our government should represent our views. We should be able to reach out to our government and make our views heard and have some form of redress. I don't think we should shy from a political fight, and I would hope that the ANC would not shy from a political fight, because you are there to represent the views of this community. That's your charter. That's your mission.
Michelle. Michelle Wallen?
Yeah, sorry. Two things. One, this idea that the whole point is to do affordable housing. That's the whole point of it. And you mentioned the small area plan and whatnot, and prior ANC resolutions. The problem is the community was never given a voice early on. And this was by design from the ANC, well, at least the former chair. They didn't want to go to the community. Once we finally get a survey, you see that over 60% of this community does not think housing is appropriate at our community site. And it isn't. It is inconsistent with the uses of that site. And, with respect also, this whole comp plan, all of this initially began before COVID, when there was a question of where can we build more housing? But with COVID, there are so many opportunities now basically all of Friendship Heights is going to be upzoned and turned into housing, all with affordable units. The Marriott Wardman, 900 units, 72 affordable. Wegmans, you've got 2 buildings. It'll be about 1,500 units. Again, all with a larger proportion or a larger amount of affordable housing than we have here because this site is so small. So all this notion of we have to build here for affordable housing, there are now tons of places to build. It is not right to give up our community space where kids who can't afford an expensive private camp have a summer camp, where people have a cooperative play group for nursery school age children. There are all sorts of activities for kids in our neighborhood and elsewhere throughout DC. It is not the place for housing. The community has made that clear. They don't want housing there. They want to preserve the green space too.
2
What
minutes.
community gives up a park? You know, opening a park is something to be lauded. And our community is going to basically give the vast majority of away, if not all, for housing that can be built anywhere else in this city and is being built all over Ward 3.
Jamie Butler. Jamie?
Yeah, sorry, I had to unmute and put a face on. Thank you. I just want to quickly say that it's just wrong to say that most people in this community don't want to see change at the community center and library, and it's unfair to say that they don't want housing. We know from our summer on doors that there are a significant number of people who do want to see it up there, number one. Number two, we also know that there are different ways to interpret the results of that survey. So it is not so clear that the numbers of people who don't want to see change up there are using is the only way to interpret those results. And the third thing, if you have affordable housing up there, which we will have, I don't think we'll have a hotel. We will have affordable housing. And if it is family housing and we are getting our teachers and our emergency responders with families, we will have kids up there and they will be able to take advantage of all the wonderful recreational opportunities that we will have. We're not going to lose. We are going to significantly add to the quality of our community. And that's the way I look at it. And there are lots of other people that look at it the same way, regardless of how many people are on here tonight opposing it. I don't believe that's the majority of people here. And I don't believe that there wasn't opportunities for people to engage. People choose not to engage and then come back and say, nobody listened to me.
And can I just say before we go on, Steve Connors, if you've got something to say, you keep coming on. I don't know whether you have problems muting or whatever, but if you want to say something, please raise your hand and we'll call on you. Rick Kempton.
Hi, actually, it's Judy Leach. I'm really interested in the fact that in 2020, this issue came up as something that was sort of reparations, we're a racist community, we need affordable housing, it's going to be a better community center, it's going to be this, it's going to be that. Until tonight, I never heard the word hotel. And I was made to feel very guilty that I didn't support something that I didn't want because I was wrong. I was looking at society the wrong way. I should have been concerned about affordable housing. But I was a reporter at one point and I learned how to read documents. And if you read the legislation or the regulations or whatever it is, it's very clear that if a developer develops a property for the city, the developer can get exemptions to where there is no affordable housing at all. And every time I've said that, people have been like, well, that's not going to happen. Like the last speaker said, everything. But, you know, I listen to what I don't hear, and I never heard the word hotel before. And that's just a big game changer, because to make a community invested in an argument that's been so divisive and unpleasant and turned literally turned friends against friends and neighbors against neighbors. And then to come back and go, that was really a hoax. We have a hotel that's looking at it that we might allow, and too bad. I just don't trust anything anymore. We were told this was a project that was for reparations, that was for bringing affordable housing into our community that kept people out. And
2
now we're
minutes.
told it's for hotels and retails. Come on, are you joking? And also one more thing, the ANC was just don't even know the word of how it shut down legitimate conversation about this. And now the ANC surprised it lost its voice. If you co-opt to just ram something through people under false pretenses, it's not good for your power either.
Let me just say on the hotel issue, I think in the fullness of time, we will discover that's a red herring. I agree with Commissioner Lynch. There is language in there. I suspect is boilerplate, but there is no hotel there. The place would be surrounded by pickets for months. I mean, it's just not going to happen. Look, let me just say, Cheryl and Andrea and Elizabeth, you've all had multiple turns. If you have new points you want to make, that's grand. But I mean, I would love to see this meeting wrap up reasonably soon. Actually, the Zoom is only till 8:30. You can probably slop over a little. Commissioner Nash has to get his. We've got to take up his testimony before we end. So, are these new points? Claudia Russell. That's a. I mean, that's a voice we haven't heard from. So, Claudia.
Hello, can you hear me? Great. So COVID was brought up, and I find that really interesting because COVID has become a point of departure in the way we operate as communities. Communities have met a lot more since COVID. Green space has met a lot more. The ability to join and get together has met a lot more because people are working independently at home. They don't have offices where they have that connection. And the last thing we need to do is reduce community services, community spaces, when this is what is the driver now in our society. Retail is declining. You can't use retail as a generator. It really is community. And how can we make this space serve the community? Because that's what it's about. Thank you.
Again, I say to people who've had their hands up and have spoken before, this is new. This is you have new things to say on these subjects.
Mine is new, Peter.
Go ahead, Cheryl.
Thank you. I just wanted to point out that I've been following the Ward 3 housing justice posts on a number of the listservs. They're extremely frustrated because Office of Planning and Commissioner Frumin promised one thing. The RFP came out with quite a different thing. And those people are livid because things have not materialized. The affordable housing has not materialized. There's going to be displacement. There's going to be, the upzoning is going to cause the usual mayhem in the neighborhood. And I see that as the writing on the wall for Connecticut Avenue. You said, in response to what you said, but there is no housing on Upper Connecticut Avenue. That's right, it's a commercial center right now. But are you proposing that it would be better for the community to have Class A market rate luxury housing lining Upper Connecticut Avenue from Livingston to the Circle? I just want to be clear on that.
What I was saying, Cheryl, is that you talked about massive displacement from naturally affordable housing. There's none now. There's none now. Section of Upper Connecticut Avenue that this proposal applies to. So
I'm talking about all of the upzoning all over Upper Connecticut Avenue and Lower Connecticut Avenue, all the way down to Woodley. That's what's proposed through Ward 3.
But how does that critique apply to this particular proposal? The Upper Connecticut.
No, it actually is relevant to Upper Connecticut Avenue. Do you want to transform Upper Connecticut Avenue into a Class A market rate luxury housing area?
2 minutes.
How do you see that will benefit the neighborhood? And we lose our commons, our Chevy Chase Commons, park, library, and community center in the process. How does that benefit the community and your constituents? I just don't see it. I've never seen it. It just seems like a giveaway.
Alan Sieber.
And the official ANC 34G survey is decidedly against it, no matter how much you commissioners, some of you commissioners dismiss it, and a couple members of the community try and erase it. It's not going to go away. And it's not the only survey that has come through with those overwhelming results that people do not want to lose the Chevy Chase Commons Park, Library, and Community Center. It's a valuable community. It belongs to the whole city, for heaven's sakes. We've talked to people from all over Washington, D.C. on that site. Claudia Russell is absolutely right. This is a vital part of our community and our city.
Alan Sieber.
Fundamental premise in this is the uses, the numerous uses of that building. If there is an RFP that gives us a credible, viable articulation of expansion or continuation of those uses, then we have something to talk about. If the mayor believes that after having done that, she wants to suggest a hotel or a Ferris wheel, we can have a serious discussion about that. But until we articulate clearly in a practical way those uses that we have been there for decades, that they will continue, until we do that, we haven't begun.
Andrea and then Michelle, and then I think we are going to turn to Commissioner Nash's broad branch rehabilitation testimony.
Michael has his hand up.
Can I, Peter, ask for one bit of clarity?
Wait, I can't hear you.
I have just a point of clarification. Several speakers have said that this RFP would eliminate the community center, eliminate the library, and eliminate the green space. And that's the giveaway that they don't like. As I read the RFP, the library is retained, the community center is retained, the green space is retained. We're talking about what, if anything, goes on top of it, not the displacement of it, the elimination of it. And I just wanted to make sure that I'm reading this right, because I've heard several people say tonight, we need to keep this community center, we need to keep this library, we need to keep this green space. And I read the RFP saying, yeah, I agree, and it's all being kept. We're talking about what, if anything, housing or otherwise, goes on top of it. So can you just...
Yeah, Commissioner Gosselin, Commissioner Ferguson is saying he needs to leave, and I worry we're going to lose a quorum to vote on my testimony. Could we do that now? And if people want to continue talking, we can do it till the cows come home. But I'd like to get this done while we still have a quorum.
Commissioners Sherman and Zeldin and Commissioner Lynch, if you're still here, please stay. Let's try to wrap this up with these two comments from Michelle Wallen and from Cheryl, and then turn to this. And let me just say thank you to Denise and to Alex, who sounds so awful, and to Andrew, and to Kent. Very much appreciate your patience and your willingness to come on.
Well, so, but Peter, before we go to the other speakers who have spoken before, can you answer the question? Am I right that The RFP calls for the continuation of the community center and the library and the green space, and we're talking about what, if anything, gets built on top of it, not the elimination of it.
Yes, I think realistically, of course, there's going to be a library, and of course, there's going to be a new community center, or nothing is going to get built. I think a question that Michelle Wolin raises all the time is, will the green space, and Peter Lynch raises too, is will the green space as it now exists stay in place? I think some of it will not, but the city, the Office of Planning made a major give by reducing the lot occupancy. So 40% of the lot cannot be taken up with buildings. Now, I believe that currently something like 60% of the lot is not covered by buildings, but that includes the parking. So yes, Michael, you're right. The two public institutions would be replaced with new public institutions, and there will be open space. And some of that open space will be the open space that you see there now, the heritage trees on the northwest corner. I think there's, DEMPED has said can't be moved. There's a question about some of the open space in between the current buildings. Okay, very quickly, Michelle, and then Cheryl, and then we're going to take up this transportation testimony and be done with the meeting. Michelle?
Okay, so just quickly about the open space. Again, they will be given more space, 60% versus 40%, which is currently unopened. I believe the RFP also talks about a rooftop, which is not the same as green space on open space on the bottom that kids can play on at any time. And plus, from what I've heard, some things are looking very big that are being proposed, but you also get collateral damage, no matter, many of the trees and open green space that are there now will be destroyed. It's just, you can't help but have that happen. But the main reason I raised my hand, Jamie Butler, with all due respect, has several times said she doesn't believe the survey and that she has gone out and spoken to people in the community who say they want affordable housing. Before this survey happened, about 2 years ago, a group of us did a petition, which we presented to the ANC. I went door to door, delivering that petition to houses. Normally I would just put it in a mailbox, but each time there'd be people outside or people who would come to the door and they'd see me. So every time I went out, I would talk to maybe 10 to 12 people. And I went out probably about 10 or 12 times. And I was not trying to sway people because I honestly wanted to know where people in this community were. And let me just say for the record, Andrea Rosen and I both will tell you, we wanted the ANC survey to be fair. And if it had shown an opposite result, we would have respected that. Unfortunately, some in our ANC didn't feel that way. But in any event, but before that, I would go out. So I went out 10 or 12 times, spoke to 10 or 12 people. The most I ever had who said they thought putting housing there was a good idea was 2. Other times it was 1 or 0. Everyone else did not want to build up that site.
2 minutes.
That's it.
All right, Michelle, dueling types of polling at this stage, I don't think advances us very far. So can I suggest, Cheryl, 2, would you cede your raised hand to Elizabeth McPike, and then Andrea McCabe is going to be the end of it. I mean, we've really got, Jim, just bear with us. Bear with me.
I have 2 quick points about the RFP.
Cheryl, you've been on 4 times. Let's try to get this wrapped up.
2 points, but I represent over 1,400 people, Peter. The RFP in general, it would behoove the commissioners to really become familiar with it because it does not require housing on the site. It does not require a library on the site. It does not require a community on the site. It does not require a park on the site. It does not require any of those things. Secondly, quickly, the second amendment to the RFP eliminates parking on the site. If those buildings are substantially demolished, your curb cuts expire. The only option for parking on the site is a non-conforming option through a public alley, which guess what? doesn't work because of fire code. That's all. Thank you.
Elizabeth, very quickly. Elizabeth McPike.
You're muted.
There we go. I didn't know that Commissioner Nash was going to present some sort of testimony regarding transportation, and so I didn't intend to make this comment, but now that I see he's about to speak, I think I will, which is that I read the listserv late this afternoon, and I want to join with a number of comments on there that congratulated Lee Mayer and everyone associated with Save Connecticut Avenue for all the hard work that they have done for, I think, 2 years now, because apparently, and the reason for these congratulations is that today at a hearing, DOT announced that there would not be, that bike lanes are not in their plan for Connecticut Avenue. And I think I have this phrasing right. I guess it was the head of DOT, I'm not sure, said, you know, this really is started out as a safety project for Connecticut Avenue, and somehow it got morphed, which I think is the word she used, into this word multimodal.
That's right.
She said, which was never the intent. And so I don't know exactly what testimony Mr. Nash wants the ANC to approve. Okay.
2 minutes. But I can tell you it has.
So I just want to add my congratulations to all the hard work that Save Connecticut Avenue did on behalf of the elderly, the disabled, the police and fire union that said the bicycle lanes would slow down the time it took for emergencies, and they were against it, and all the other very, very good art. The 98% of businesses from that they did a door-to-door survey and conversation with, from the Circle all the way down to Calvert, 98% opposed it, and on and on and on. So anyway, I just want to
thank you.
I want to thank and congratulate Save Connecticut Avenue for the very persistent and intelligent campaign. And it was also just, this will take 5 seconds. It was just also this breath of fresh air that I felt for the first time in a long time that, oh my gosh, citizens really can make a difference, because I have not felt that.
Ms. McPike, my testimony has to do with installing sidewalks on Broad Branch Road between Linnean Avenue and Beach Drive, as well as improving drainage and motor vehicle safety.
So
okay. Well, that's fine, but I'm glad it gave me the opportunity to thank Save Connecticut Avenue, and also the chance to say how it just lifted my spirits to see that people in a neighborhood together can have some say so about what happens to their neighborhood. Thank you.
Thank you. Andrea, very quickly, is your remark about the zoning issue or some other issue? And can you make it 1 minute so we can get to...
Yes, it's about the percentages and this canard of overwhelming sentiment against affordable housing. The survey is published on the ANC website. It's been discussed at meeting after meeting. Question 9 clearly says 40% of the respondents in favor of housing, 47% against. That's not an overwhelming difference. Go read the survey. Don't listen to what people are saying, these wild opinions. Look at the facts. Thank you.
All right, we are ending the discussion of zoning at this point. We will take it up again next Wednesday. No issue ever dies here. It just goes on to the next meeting. So with that, let's just turn to Jim Nash's Broad Branch rehabilitation testimony. And Jim, if you could just briefly summarize it.
Yes, I will. This should all be familiar to commissioners because we voted on a resolution on this matter in July of last year, and I've sent it all around to you. This was a project that DDOT started several years ago that never got funded. It would install sidewalks only on Broad Branch. There's no room for any bike lanes there. It would improve drainage. This road between Linian and Beach Drive is prone to flooding, and it would also improve motor vehicle safety. And I'm asking the ANC to approve this so that when I speak at April 30th at the Committee on Transportation and the Environment at the budget hearings, I can speak for the commission. And as I said, we already passed a unanimous resolution on everything I'll be saying.
Do any commissioners have questions about Jim's proposed testimony? Jim, you want to make a motion?
Yeah, so I make a motion that ANC 34G approves my testimony on the Broad Branch Road Rehabilitation Project. Is there a second?
Second. All in favor, please raise your hands. I can't see. Can you see everybody?
Yeah, everybody's up. Yep.
Okay. Thank you all very much, commissioners. Appreciate it.
Apropos of Jim's having his testimony done, I owe DPR testimony, and given that they did not put a single additional dollar in for the new community center library, I've got something to talk about, and I will get you testimony. We may have to take it up at the April 11th meeting. Do any other commissioners have anything they need to say right away, or could we end this at 8:45? Is that okay? With that, I'm going to turn off the tape as soon as I figure out how to do that. Stop recording. And we are